Good morning, ladies and gentlemen. We are here in the Superior Court of Toombs County to address the sentencing hearing of Keys Sanders. Mr. Sanders is here with his lawyer, Ms. Tina Maddox of the Toombs County Bar. Ms. Maddox, you retained or appointed?
Retained, Your Honor.
Thank you very much. The prosecutor in this case is Jennifer McComas. I note that some of you are wearing masks. You're welcome to leave your mask on, but if you're addressing the court, we will ask that you take your mask off so that we can hear you clearly. That is, of course, important. This young man has entered a guilty plea to, as I understand it, 2 charges of vehicular homicide and then an additional charge of feticide. Am I saying that right?
Yes, Your Honor.
Very well. Thank you, Ms. McComas. Is the state ready to proceed with the sentencing phase?
Your Honor, we are.
And how about you, Ms. Maddox? You ready to get started?
We're ready to proceed, Your Honor.
All right. This is, of course, an open-ended plea, meaning that the defendant has entered his guilty plea with a hope that the court will sentence him, I'm sure, to the lighter side of the requirements, and the prosecution, I'm sure, will ask for something more significant than that. So I'll hear from both sides. Will it be an evidentiary presentation or just a recommendation?
It'll be a recommendation and proffer by the court, Your Honor. With the court's permission, prior to the call of proceedings, I've removed my mask so that the court can adequately hear what I'm planning on proceeding on today.
Very well. Evidentiary presentation or just recommendations?
Just recommendation and proffer, Your Honor.
Very well. All right, I'll hear from the state.
Your Honor, we are here today, as the court has already identified, for a sentencing hearing. The court needs to be reminded that based upon the Georgia Code that the defendant, Mr. Keys Sanders, is subject to 3 to 15 years of each count of vehicular homicide for each victim he has in this particular case. Additionally, the state will be also prosecuting and requesting the court enter a sentence specifically as to the unborn infant child that was subject to this wreck as well. I will identify her as Baby Jones, who was the baby of Miss Kayla Jones. Additionally, Your Honor, based upon the requirement of the code, the victims of this incident, this horrific accident, of Miss Sammy Ellis as well as Seth Smith's families are present before the court, and they may wish to make a victim impact statement separately before the court. I just want to briefly remind the court that although Mr. Keys has a good reputation in this community, there is nothing that will replace the lives that have been lost today. And the subject to his recklessness and driving under the influence of drugs and alcohol, he has killed Sammy Ellis as well as Seth Smith. And now Miss Kayla Jones will be robbed of her baby Jones. We are arguing, Your Honor, that this child has a viability. She was approximately 5 months along, and there was an argument to this court that this too has robbed another member of society and another member of the family at this particular time. So, Your Honor, we would be requesting at this particular point, due to the heinous nature of the acts and circumstances that have happened in this particular case, that Mr. Keys Sanders be required to serve the maximum sentence. That would be 45 years for each incident. That he would be subject to incarceration immediately. He does not have a right to remain on bond.
Hold on, ladies and gentlemen. I understand that emotions are high in this case, but it is important that you maintain decorum so that we can complete this matter. I recognize this young man is young himself, and I understand, Mr. and Ms. Sanders, the emotions that you have, but please recognize this is court, and we do have to, please be quiet. Continue with your argument.
Your Honor, also at this point in time, with that interruption, I would also remind the court that I would have rebuttal after the presentation of the defense argument to the court. It would be, though, again, reiterating our position that he should be served the maximum amount of sentence. Additionally, Your Honor, he was charged with DUI, which was an underlying offense that caused the death of these particular individuals, and wish that to make that a consecutive sentence for the court as well. And so to this extent, Your Honor, we are requesting the maximum amount that can be prosecuted under law to justify and to finally get justice for these particular individuals who were killed.
Thank you, Ms. McComas. All right. If you'll step back, we'll cede the well to Ms. Maddox.
Your Honor, I'm here on behalf of Mr. Sanders today. However, we're here to ask the court to consider leniency in this matter. He is the tender age of 17 years old, having only recently turned 17 years old. What the prosecution fails to indicate or reflect is that Mr. Sanders, since this happened, has been living in a self-imposed prison of some sort. Your Honor, we're not asking for no time of incarceration. Rather, we're asking for a period of 15 years on probation, subject to 3 years of incarceration, with the same sentence on each count, all to run concurrently. Mr. Keys, additionally, Your Honor, will be asking for the court to impose a first offender sentence, as he has no criminal history. Mr. Sanders has, up until this point, been a law-abiding young man. He has done well in school, and his plans were to enter the military once he finishes high school. If the court considers the first offender sentence, then at some point in the future, he would in fact be able to go forward on that path. Although it would be delayed by a great deal, he would be able to go forward on that path, but have the possibility of living out the rest of his life without a felony criminal conviction. I don't think that the state has taken into consideration the time that my client has spent already incarcerated at his tender age of 17, the time that he has spent thinking about his actions and the loss of his friends and this unborn child. He is sincerely remorseful, and for those reasons, Your Honor, we're asking that the court consider a much lower sentence than what is requested by the prosecution. Thank you.
State does have the last word.
I appreciate counsel's argument to the court, but there's adult consequences to the actions taken by the 17-year-old. He took a vehicle and essentially made it a 2-ton killing machine.
What?
And with those actions, with his reckless disregard for the life of other people and individuals, has resulted in these terrible circumstances and the death of 3 individuals, including an unborn child. With that, Your Honor, we request the maximum amount, no first offender status whatsoever. It is actually an insult to the victims of these family members who are left remaining for him to be able to sit and just simply return to life as normal when their loved ones have been robbed.
Ladies, hold on, again, ladies, if you'd like to remain in the courtroom, you'll need to keep your hands in your lap and keep yourselves quiet. Sir, same for you. I appreciate your efforts to keep the ladies apart, but I hear you muttering over there, and I need you to stop that. Okay? Thank you, sir. Go ahead, Ms. McCollum.
Again, Judge, these were adult choices, and now he needs to suffer the adult consequences. And I yield the will, Your Honor.
The court has had the opportunity to both consider the arguments of counsel. I have reviewed the pre-sentence investigation. I recognize this is what would be considered a good kid, so to speak. An AB student, it looks like, a member of a couple of different clubs at the school. I think I read he was a member of the baseball team. I mean, we're not talking about some young person that has been in juvenile court since they were 13. We are talking about a young man, age 17, doesn't feel like an adult, but for the purpose of this discussion is an adult. And I recognize that's difficult for parents to understand. I'm certain that it's difficult for Mr. Sanders to understand. He's a junior in high school. I'm sure he doesn't feel like a grown-up. And yet he was trusted with a vehicle, trusted not simply by his parents, who I believe, as I understand it, let him drive their car, but also trusted by the young people who rode with him and their parents to let this young man with a valid driver's license drive their kids around, even if they didn't know it. They knew they were friends, and they understand that sometimes friends drive friends around. That's how that works.
Good kid.
Nevertheless, 2 people are dead, a baby is lost. The court cannot ignore that, cannot say this is a probation type case. I don't believe, Ms. McComas, that it warrants 45 years of this young man's life, but I also believe it warrants more than the 3 years suggested by Ms. Maddox. Thus, the ruling of the court will be as follows. With regard to count one, 15 years to serve. With regard to count two,
No.
15 years to serve,
That's
except
my baby
that,
boy.
except that 5 of that, excuse me, the last 10 of that will be on probation.
Oh, no.
That'll be consecutive, meaning that it's 20 years to serve with 10 on probation. And then with regard to the third count, it'll be 15 years of probation concurrently with the second count.
Mess up
It's
the county.
DUI will be,
My daughter is dead.
ma'am, I please ask you to rein in your emotions. The DUI, the 12 months on that will be served concurrently with the probation, thus that 1 year will begin with probation. The standard DUI requirements will be included, including the 40 hours of community service and the other things associated with that. All fine, there'll be a $500, excuse me, a $1,000 fine on the DUI. Restitution, the issue of restitution, if there is any, will be addressed by separate order at a later date. That'll be, we'll have a separate hearing on that issue. Ms. McComas, have I gotten everything on this one?
Yes, Your Honor.
Any questions on behalf of the state for the purpose of the order?
No, Your Honor.
And on behalf of the young man?
No, Your Honor.
All right. That will conclude the matter today of State versus Sanders. Thank you all for your presentations.
Thank you, Your Honor.
Thank you, Your Honor.